Today, I hope to address in the brief time I have the necessity of probating wills to clear title of a deceased owner. The question came to me as more of a complaint. A listing agent complained that attorneys are often telling sellers of property that the will of the deceased owner does not have to be probated to convey title. But then the title is examined by the title company and a probate is required, which is exactly what the listing agent advised originally. Well, the truth is, as long as the devisees under the will are the same as under Texas law when there is no will, there may not be a need for probate. Under Texas law, if the property is community property and one spouse dies, the property automatically goes to the surviving spouse if the deceased spouse had no children from a prior marriage. If the deceased did have children from a prior marriage, then his or her interest goes to all of his or her children. There are other ways to clear title without probating a will. If the estate is small enough and devisees under the will are the same as the heirs, then we can use affidavits of heirship signed by two disinterested parties who have personal knowledge of the deceased family and can attest to who the heirs are. The affidavit needs to have a copy of the will attached and will be recorded in the real property records. All of the heirs will then be required to sign any deed conveying the property. This heirship affidavit process can be used, but you need to understand that many title underwriters have certain time restrictions, meaning they will not let us use heirship affidavits when there is a will unless there is a time that has passed from the date of death to the time of subsequent conveyance. This waiting period can range from as little as 2 months from the date of death to the time of sale, all the way up to 2 years. Finally, there is one more way to clear title when a decedent dies, leaving a will, but the estate is not big enough to warrant a full probate. And this is when the will leaves property to someone other than who would inherit by law. The will can be filed as a muniment of title. And basically, this works like a deed to convey title to the devisees under the will. Probate is still filed, but only for the limited purpose of serving as a muniment of title. This process is much less expensive than full probate. If you have further questions regarding estates and probate, please email me at tipoftheweek@allegiancetitle.com. We at Allegiance Title work hard to earn your support. We want your business and look forward to the opportunity to work with you and your clients. Thank you.